Welcome everybody to the Injury Board webinar series called Ready to Rebound. And this is a series put on by the members and firms at the Injury Board, which is a national network of attorneys. And today we'll be talking about the business interruption claims, what's going on with that, and what businesses and organizations of all types should be thinking about it. As many of you know who have been on our series, we've covered a number of topics. This falls into our category of remote work and small business. There are additional titles in this talk. So how to set up remote work. Hopefully you've come a long way in that regard since the beginning of COVID-19. Payroll protection program, something that's still applicable and some businesses and organizations still filing. And then business interruption claims. And the idea is how can we best position ourselves to get ready to get back to work? What are those things that we can be doing in the meantime to protect our organizations, protect our families, protect our communities? Injury Board is made up of a national network of firms and attorneys. And this particular webinar is being sponsored by the firms that you see here. And we're thankful to them and for their generosity in making this available. Generally, the Injury Board is a group of experienced trial attorneys from across the US and the UK. They're trial bar leaders and they're board certified attorneys. And we'll have two of those speaking with us today as our panelists and experts in business interruption claims. So our speakers today will be Brian Katz and John Creevy. They're of the firm Herman & Katz in New Orleans, Louisiana. And at this point, I'd like to bring in Tom Young, who is the co-founder of Injury Board, a member attorney. And Tom, maybe you can put some context around what we'll hear today, who our audience is, because this is not our traditional members, but instead businesses and community organizations that they've invited to participate and hear some of this good information. And then what we should think about in these days.
Yeah, great. Thanks, Mason. Thanks, everyone, for joining us. As Mason alluded to, we are a group of about 100 law firms around the country. This particular webinar, of course, is not necessarily for our members, but for our members' friends, families, colleagues, networks of business associates, and what have you. That may have experienced losses associated with the COVID-19 pandemic, particularly with regards to insurance policies and business interruption provisions of those insurance policies. There's been a lot of talk over the last several weeks about whether these policies apply or not. The insurance industry in general is denying these claims. Your local trusted broker has probably told you your claim will not be paid. While that is all still up for debate, there is reason for some optimism that may not be the case. And so we do have Brian Katz and John Creevy with Herman & Katz, as Mason alluded to. Their firm is really one of the major leading firms in the country when it comes to trial work and litigation. Amongst many other projects they've worked on was the BP oil spill case back in 2010 up until very recently. It was a very long litigation, the largest litigation really to date in the history of the United States. And many of our business folks on this call probably participated, particularly if you're located in the Southeast, in that claims process. So Brian and John and their firm have a great deal of experience with complex litigation and matters such as this. So again, appreciate Mason's help and moderation in this. Afterwards, we will share the recording of this webinar with all of those attended, and you're certainly welcome to pass that along on social media to your friends and colleagues as well. Because as Mason said, we're getting ready to rebound, and we hope these tools help you do that. So I'll turn it over to Brian and John.
Thanks, Tom. And Brian, go ahead. I'm sorry.
Oh, go ahead. I wasn't sure if you were going to step in, Mason, but thank you, Tom, and thank you, Mason. We are happy to present this on behalf of our firm, Herman & Katz, and on behalf of Injury Board, who we are a proud member of. And look forward to providing you some advice and trying to answer questions as best we can relating to your particular needs or concerns regarding your policies or just policies in general. And so thank you. So the big thing that we think about, kind of what we want to cover, and we want to spend about a half an hour very generally covering all of these topics, and then give you a half an hour to ask questions about what we presented. So the things we're going to talk about is what is covered under a policy, what is excluded on a policy, how to make the claim, what happens when the claim is denied, and then what are the likely outcomes of post-claim world in the COVID-19 context. So in terms of what's covered, you've got the first thing that you're really looking to cover is business income and extra expense. And business income is your losses of actual income and any expenses that you've made over and above your regular expenses in order to keep your business operating as best you can. So in each of the policies, business income will be defined specifically. So you need to look at your policy and figure out exactly what that definition is. And there's usually a numerical example of how that is to be calculated. Extra expense is an amount that you spend over and above to keep operating. So you've got, if you've opened up, if you sent everybody home with a laptop and you had to purchase laptops, if you had to purchase apps or other mechanisms to work remotely, that is all included in what extra expense is. The big thing that you need to be concerned with in making sure there is coverage under business income and extra expenses, what is typically the policies define it as, is there actual or direct physical damage to your premises? So if there is, so you've got to prove that. And we're going to go into some detail about that in a moment, but that's usually the magic language, is actual or direct physical damage to the premises. The next area of insurance coverage that you're going to look for is civil authority. That's the government issuing an order to shut down your business, either as non-essential or limiting your business as essential. And the orders, and we're from Louisiana, so the order in Louisiana specifically referenced actual or direct physical damage caused by COVID-19 to try to help us gain access to our insurance proceeds. Whether that will ultimately work, we'll talk about in a little bit more detail. But in civil authority, you've got to prove that there was a government order, number one, and that there was, number two, there was actual or direct physical damage, not at your premises, but in a location within some geographical area around your premises. Your policy is going to define what that geographical area is. It could be blocks, it could be a mile, it could be the greater area of your particular city. Other avenues of coverage are dependent or contingent business. That is if, for instance, if you are operating a widget factory and you are your business is contingent upon getting products from other places, and those places are shut down, so they can't manufacture component parts to your product and you can't get them, that you may have coverage under the dependent or contingent business portion of your policy. You need to check the policy to make sure you've got that. Another way of getting coverage is communicable disease and contamination coverage. If you've got that specific coverage, and not a lot of people will have it, but if you do have it, it'll make your life a lot easier in terms of recovery. Event cancellation, if you've got conferences that are scheduled, or you're in the hospitality industry, a lot of those industries have event cancellation coverage that you either hopefully have or could have gotten. The supply chain and trade disruption is similar to dependent or contingent business in that you are relying on a certain supply chain to get products to you in order to do your job. And if that supply chain or the trade is disrupted, then there is insurance coverage to provide that, provided you have that in your policy. Some policies have ingress and egress coverage, and these are typically in separate riders. All of these things are kind of in separate riders, except for the business income, extra expense, and civil authority, which should be part of your main policy. But the dependent and contingent business, the communicable disease, event cancellation, supply trade, ingress and egress will come in separate forms in the policy typically. And if ingress and egress coverage will provide for if the city is shut down and people can't get to you, or you can't get out to provide your services, there'll be coverage for that. There are also specific pandemic coverages. Some of you may have heard about Wimbledon, the tennis tournament in England, who has the pandemic coverage, and they had paid $2 million a year for the last 17 years for pandemic coverage, and their claim was granted, and apparently they were paid over $140 million for the losses that they sustained to cancel this particular event. So those are the big picture coverages that you will likely have in your policy that hopefully provide you some coverage. Now, I want to dig down into the business income and extra expense portion of it, because that's probably the biggest portion of the policy, and really dig down into the actual or direct physical damage. And
I don't mean to interrupt, but I just wanted to let the audience know that we'll be accepting questions through the Q&A feature at the bottom of your screen. So if you are on your laptop or on your phone, you should be able to see a menu that comes up with Q&A, and feel free to ask those questions at any time, and we'll either interject them into the conversation or we'll address them at that Q&A period at the end. But before I knew we were going to get into some meat here, so I wanted to make sure that the folks have any questions, they have a forum to do that. Thank you, Brian.
Thank you, I appreciate that. So these are just examples of what actual or direct physical damage are. Typically in your commercial property policies, it provides coverage for things like a hurricane or a tornado or a fire. And we don't think of something like a virus or COVID-19 causing actual or direct physical damage to your property. But in fact, courts have held around the country many examples of things that are not physically damaging to the property from a visual sense, are considered direct physical damage. For instance, in one case, the land under a home was washed away by a creek, and the home wasn't damaged, but the land was gone. And it had completely destroyed the foundation, underneath the foundation. But the court ruled that the home was damaged as a result, even though the home wasn't the type of physical damage you would expect. Next example is a church became uninhabitable due to gasoline accumulation under and around the church. That was considered direct physical loss. Asbestos is a pretty good example. That's been considered a direct physical loss. E. coli contamination has been considered an actual or direct physical damage. Chinese drywall, the same type of thing. If you're living in a house, the drywall would emit poisonous fumes, and it didn't look like it caused any actual direct damage, but in fact it did, because it made the place uninhabitable, and it did destroy component parts of the property. There's a couple of more examples. You kind of get the picture. It's really going to be fact specific and court specific. So if you get to the point where you're litigating the case, you're going to look at your state law, and you're going to look at the facts of the case and try to make an argument that these things, while there's nothing exactly like COVID-19, but they're almost analogous to COVID-19, do cause actual physical damage under the terms of the policy and under the definition of the policy. So one more thing is, if the policy doesn't adequately define actual or direct physical damage, it's typically going to be considered ambiguous. And most states' laws say that the ambiguity will inure to you, the business's benefit, not to the insurer's benefit, because the insurer has written the policy and the insurer had the opportunity to further define direct physical damage. So if it's ambiguous, you will get the benefit of that.
Brian and John, there's a quick question I'll interrupt because
Sure.
it's pertinent to what we've just covered, and it's from Michael Chamowitz, and he writes, are any of the coverages you've described as riders typically included in generic business owner policies for restaurants? Are these the things, in other words, that we're seeing in a general policy, or is this something that they've had to add on?
Well, you're going to have, the way the policies are written is there's going to be a form or language, and the forms are created by this ISO. It's an insurance services organization, and many of the insurers, with some exceptions, use these forms to create their policies. And they'll have a form for business income and extra expense, which includes civil authority. So that'll be one form. They'll have a form for contingent or dependent coverage. They'll have a form for pandemic coverage, a form for, and they'll just kind of pull them all together and put them into the policy and create a policy. Now, Lloyd's of London, as an example, doesn't do it that way. They kind of more do it as one, but they typically will, in the restaurant scenario, I've looked at a couple of restaurant things, and they've got pieces and parts. So sometimes they'll have, communicable disease coverage because they're worried about that, and sometimes they won't. And hopefully the agent has walked through the owner of the restaurant enough to explain to them what the coverages are that are available, and the business owner has made hopefully a educated decision on what he can afford and can't afford, and what ultimately ends up in the policy. So I think that answers the question. It could be both, but it's more likely it's going to be added as not necessarily as a rider, but as a form into the policy, and it makes the whole of the policy. Does that make sense, Mason?
It does. Thank you, Brian.
And if there's a follow-up question to that, just put it in the chat, and we'll address that. I think John has got. Let me wrap up the physical damage. So the big takeaways on direct physical damages is are you able to use the building for its normal purpose? If you're not, like in this situation, our argument is going to be that the COVID-19 makes it unable to be used for its normal purpose. Secondarily, but not any less important than the first one, is that you may have to prove some physical presence of coronavirus, either at your premises for business income or extra expense, or through exposure of employees or relatives of employees. For civil authority, you may have to prove presence of coronavirus within that geographical area. So arguably, if there's a hospital a mile or two away from you, you can easily meet that burden for the civil authority portion. And so there's going to be lots of things to consider when you're looking at the policy and trying to analyze the policy in coordination with the facts of this particular this particular event. And I believe John is going to take over and talk about the exclusions.
And let me just make one comment. I was a CPA before I was an attorney, so I focus on some different kind of economic aspects of these claims. And let me just mention also, because I don't think that was covered yet, when it comes to some of this coverage, there's some differences in the period of time that may be covered. For instance, for business interruption or for civil authority coverage, and business interruption coverage will frequently provide coverage for the period of disruption up to maybe 12 months of lost profits, depending on the language. But that's typically the ranges that the policies can run in. Whereas civil authority usually has a much shorter period, because those types of claims are generally not going to be as extended as we're running into now. So a lot of the times the civil authority language will limit the losses to 30 or 60 days, beginning within 72 hours after the original civil authority order. So the amount that can be recovered under those different kinds of policy provisions can differ greatly. And one of the things that we're running into is most of the businesses that we see are they're closed and they're losing their business really because of the civil authority issues. They have been ordered to close or to not operate at their fullest capacity. And so there's some differences maybe in the way that that coverage may provide relief for those business owners. But let me talk a little bit about the exclusions, because I think this is really where where most policyholders, business owners, run into their concerns, and if they have spoken at all with their agent or broker, this is where the agent or broker tells them that they're very likely not going to succeed. The first has to do with the virus exclusion. Starting about 15 years ago, I think in 2006, the Insurance Services Office, ISO, issued form language for insurers to use as an exclusion provision in policies, excluding coverage for damages or well, essentially excluding coverage for virus-related losses. And that, on the surface, if you look through your policy and see that you have a specific page that calls for a virus exclusion, that would seem to be pretty well on point for the issue that we're dealing with now. We don't really see it that way. We see that there is opportunity for business owners, insureds, to be able to argue that even if there is a specific virus exclusion in the policy, that may not apply to certain types of coverage. For instance, if the policy, if the property policy covers issues concerning liability, there's an argument that the virus exclusion may apply to some, well, I guess regardless of whether it includes a liability component. There is always going to be a question with these exclusions as to whether they apply to all of the types of coverage that is made available under the policy. Frequently, although there's form language, the virus exclusions are not very clear. The ISO tried to make them as comprehensive as possible, but if a business suffers losses, not because there was virus on the site, but because they were ordered to close, they were concerned about closing, their employees wouldn't come in, or they had additional costs maybe continue operating, and would cause for them to have lost profits. It's not clear that any of those were really directly related to the virus. In fact, a lot of the orders that were issued by the municipal authorities for closures had to do not necessarily specifically with the virus, but reducing the strain on the medical system. And so there are a number of reasons why businesses could suffer losses as a result of COVID-19 that may not be specifically excluded by the language of the ISO standard virus exclusion language. This is an issue that's going to work its way through the courts. There is not really a precedent for the detailed definition and parsing of how these virus exclusions are going to apply, but it is clear that from the policies that we've looked at, the virus exclusion language can be ambiguous. And again, as Brian had mentioned, frequently most states will interpret these contracts against the drafter, so that if the insurance company drafted the contract and they did not clearly define what these exclusions were supposed to apply to, the courts are inclined in most jurisdictions to find that that there is coverage in those situations rather than expanding the exclusion when it's ambiguous. There's questions as to how this virus exclusion may apply if there is a virus that's specifically found on the premises, if an owner, employee, customer has an infection, how it may apply to cleanup, the prophylactic steps to prevent either infection of employees or customers or social distancing. There are just a number of questions with this that have yet to be determined. So I guess the point that we would leave y'all with is that just having even if there is a specific virus exclusion in the policy, it is not clear at this point that that will prevent coverage from being applicable in this situation.
John, let me stop you right there if I can, and for
Sure.
you and Brian, because I think you've covered the spirit of this in your answers so far. But let me get these specific questions so we make sure the attendees are getting an answer to the direct question. One writes, the general consensus I receive from my agents is that the civil order does not qualify, even if I have this coverage, as a covered loss because the reason for the civil order was COVID-19. So the guidance is that it's not a covered loss. What are your thoughts there?
Well, my thoughts are, and again, these policies are all unique. There are differences in the language. We've reviewed. I can't tell you how many policies that we have reviewed, specifically looking at the language, and they're all different. Some of them specifically say that included with the virus exclusion is any related type of actions by government or military authorities that are related to those to a virus. Some do not. Clearly the insurance companies, and I guess what it really comes down to is the insurers, we feel quite confident across the board, are going to take the stand that if there's a virus exclusion, that would prevent the civil, that was the cause for the civil authority action, and the virus exclusion would prevent a claim under the civil authority. We don't believe that has been established, and either on a large basis, and certainly with regard to some of the individual language we find in these policies.
And Brian, if I can bring you back in, I'll ask you the follow-up question. It's, we own a restaurant and have a pandemic closure call due to microorganisms specifically, right? The question is, do you feel COVID-19 will be covered as a microorganism? My research is that a virus may not be covered as a microorganism.
And I think John is probably going to hit on that in bacteria, but I think my thought is that the microorganism is likely not COVID-19. But I have to go back. You have to look at the definition in that particular exclusion in the policy, and it may include a virus exclusion within the microorganism portion of the policy. John, do you look at it differently than that?
A little bit. The microorganisms were specifically identified as exclusion items in many policies, even before the virus exclusions came in back in 2006. It was a separate type of a risk that insurers generally would include a specific exclusion for. Technically, biologically, a virus is not a microorganism. Microorganism is a living thing, and a virus is not a living thing. So, by definition, a biological organism or microorganism exclusion would not include a virus. But again, so I think that answers that question, or at least that's our take on it from a scientific standpoint. Microorganism exclusion would not apply to a virus.
Thank you, gentlemen.
Okay. So moving on a little bit from the specific virus exclusion, most policies also have exclusion for pollution and contamination. Typically, pollution and contamination it has been interpreted, the language of the policies and the interpretation of those have to do with what you would consider to be typical types of contamination. Petrochemicals, caustic substances, whether they are gaseous, liquid, solids, a number of type of contamination that could be found on a property. Some of the contamination and pollution coverage exclusions that we have seen specifically identifies viruses, microorganisms, bacteria as potential pollutants. That's pretty rare that those are specifically included as a pollution and contamination definition. And just as a point of reference, most of these exclusions, they're usually spelled out in specific pages of the attached to the main policy. And the pollution exclusions will generally be an absolute exclusion or any coverage related to pollution. But again, these are kind of industry dependent policies, and there are some industries where pollution is a legitimate risk, such that either the pollution exclusion is more limited, or there may not be a pollution exclusion. But for most businesses who don't expect to have a major pollution problem, they'll have a policy that has a pretty extensive, comprehensive pollution and contamination exclusion. That, in general, is not going to apply to something like a virus. By definition, the vast number of pollution exclusions that we have reviewed, we don't believe that the definition of pollution that is used in there and the interpretation of the generalized pollution and contamination exclusions would apply to the COVID-19 situation and a virus in particular, especially because keep in mind that most of the business losses out there are being caused not because there was a specific virus that was found on a site. This isn't Legionnaire's disease in a hotel. This is concern about the possibility of spreading virus in places. While, and again, some of the language can be more expansive, but in our interpretation, there is we would expect that there's going to be a lot of opportunity to argue against any claim by the insurer that there is no coverage because of a pollution or contamination exclusion in the policy. We have bacteria on the list, but that's that kind of loops into our discussion of microorganisms, and that bacteria and other types of, which is a microorganism, and other types of microorganisms are frequently specifically excluded from coverage, but those would not, and that's why ISO in 2006 developed the virus exclusion language, because virus was not included in those microorganisms, bacteria exclusions. So I'm sure that there are likely to be many questions about these exclusions and how they apply. Again, these are very policy specific. The state laws are going to have a different kind of a focus on how these are interpreted, but we believe that there are arguments as to why these exclusions either should not or may not apply to the COVID-19 situation.
So when, go ahead, Mason, I'm sorry.
I think we're just wrapping up with John.
Yeah, Brian, I think you were going to move on to talking about the process of actually making a claim.
Right. So one of the most important things that you need to do now, and if not one of the most important thing you need to do now, if you haven't already done so, is to make your claim. The policy has language in it that specifically states that you need to make the claim timely or promptly or as soon as practicable. So that means now. It means you're getting towards the end of when a court would consider that reasonable. You want to call your agent and make the claim. you need to begin gathering some documents to support your claim. You don't need to produce them right now, but you need to begin gathering them. And we're going to go into a good bit of information, good bit of detail about those documents, or they'll be as part of this. They'll be a part of this PowerPoint that you'll receive, so you'll see what kind of information you're going to need to start gathering. Once you've made the claim and you've called your agent, we're telling our clients to be as general as possible in terms of the claim. And you want to say, look, I was shut down by government order, and I had actual or physical damage to my premises or premises around me due to the COVID-19. And ultimately, you'll make the claim. There'll be some follow-up from your insurance company asking you some specific questions. You've got to answer those truthfully. And then ultimately, what are your expectations after making the claim? And let me back up for a second. You can make the claim yourself, or you can have an attorney do it. We've kind of been walking our clients through making the claim on their own, and because we fully expect those claims to be denied, giving them the instruction to make it as generally as possible. In terms of expectations after making the claim, the expectation is that the claim is going to be denied. I haven't seen one yet besides the Wimbledon deal that I talked about earlier, and you can switch slides, Mason, is the claim is going to be denied. Don't be discouraged by that. The importance of making the claim promptly is that if and when you decide to file suit later on, you're going to have the opportunity to do so. If you don't make the claim timely or as soon as practicable, the insurance company is going to argue that since you didn't give them prompt notice, that your lawsuit is not valid because you didn't follow the terms of your policy. So you're going to get this denial. It's going to be in writing. It's going to tell you exactly why the insurance company believes that your situation is not covered under the terms of the policy. They're going to cite which exclusions are that they're considered, and they're going to tell you why it doesn't fit. And so just be prepared for that. It's good for you to have that. Ultimately, if you decide to file suit, you'll be able to provide that denial letter to your attorney, and your attorney can create a strategy for how to defeat the insurance company's denial in terms of the pleading of the lawsuit and in terms of strategy of developing the theory of the case and presenting the case to a judge or a jury ultimately. So typically, most policies have a 2-year period within which you have to file suit. So the important thing now is to make the claim. If you get denied, so what? Everybody else is getting denied as well. You then have 2 years or 2 years from March of 2020 or somewhere in there to determine if you want to file suit. A lot of things can happen in the next 2 years. And we're going to talk about some of those things towards the end and why you should make the claim now and see what happens over the next year and a half before which will give you a lot more information about whether or not you want to file suit.
Brian and John, this is a great point to step in and ask you a quick question. And so our earlier questioner followed back up and he said, I mistyped. Basically, the covered closure coverage. So the coverage was for, quote, pandemic due to microorganism, unquote. If COVID-19 was considered a microorganism, then we would have been covered. So it sounds like, this was earlier before you just started speaking, his comment sounds like this will not work in our favor. But what I'm hearing you say is that maybe even with that, there's still that reason to go forward with at least the filing.
Yeah, we're telling everybody, regardless of what you think your policy says, there's no downside to making the claim now, because we know they're going to blanket deny virtually every single claim. If you don't make the claim, though, you're going to lose the upside of getting some type of coverage or some type of funds that are created by the insurance industry potentially, and we'll address this a little bit later, to pay these claims. So you got to make the claim. There's potential ambiguities in your policy. The insurer may not be applying the exclusions properly, like in that coverage of microorganisms, because from what you're saying, it doesn't seem like the insurer would be applying that properly. So, or your agent who's giving you the advice. Agents are instructed by the insurers that there's no coverage. So the agent's not going to be very helpful to you in terms of providing you advice on whether or not there is coverage. We've suggested to all of our clients, make the claim, there's no downside.
One more quick question. We represent a small business, the writer writes, who submitted a claim and received an ROR naming multiple potential exclusions. It looks as though they'll deny for lack of, quote, physical loss or, quote, damage, though neither are defined in the Lloyd's policy. They point to a bacteria pollution and also a seepage contamination exclusion, which don't look to apply, primarily hanging on the civil authority. Can you press the insurer for failing to produce evidence on each potential exclusion? And if so, how far?
Well, I think what you do, and every state's got different bad faith statutes. I think you need to read your bad faith statute to make sure that you're on the right point. But I would follow up with a letter to them, and it doesn't hurt when you get the response. If your letter says, "Hey, we're not really following what you're telling us. We don't think those apply. Can you point to examples as to why they do apply?" And they give you some, ambiguous or non-response response. I don't think it hurts to document their failure to adequately respond to you in order to set them up for a bad faith adjusting of your claim. And I think you can push them as much as you can until you have to file suit. I don't think it hurts to continue to do that until you get an answer that's satisfactory, or it's obvious that you're not going to get an answer and you've done all you can do. And I think, John, you're going to take over.
Yeah, and before I move on to the next section, Brian, let me just clarify one thing.
John, I can't really hear you. I think you're turning away or something. I don't know. Perfect.
Is that better?
Much better.
I just wanted to clarify one thing. I think that you had mentioned something about maybe having 2 years to file suit. I think that's true in a lot of states. I think that it's going to be important for anyone who has filed a claim and is denied and is interested in further pursuing possible compensation to make sure they speak with an attorney in their jurisdiction to make sure that they are fully well aware of what their time limits are in being able to file a lawsuit or otherwise further pursue the claim, either for coverage under the policy or for bad faith denial or for anything else, because there are going to be, I'm sure, some states and some situations where that may be as little as 1 year. I don't know if there's going to be any that might be less than a year, but every jurisdiction is going to have a different kind of a take on that. So we can then move on to what can insureds and business owners do at this point to prepare for a claim that they're going to be filed. And we've got a couple of pages of information here. I won't really go through all of it, but it's going to be important to document everything that's going on at this point, because by the time, I guess, one of the short answers is we don't expect that there are likely to be insurers that are going to voluntarily acknowledge payable claims for COVID-19 losses, except in some very limited situations. There's likely to be a dispute about coverage and the amount of any claim. That is a process that's going to take time. If it does need to be litigated, that could be years. And the records, the timeline, the experience of what happened, those can be harder to recall or to recover if needed for litigation or other claim support services. And so it's important to know upfront what it is to pay attention to. A timeline is important, just of when things went into effect, when closures happened, when certain decisions made, who was involved in certain processes of all of that. The government orders, obviously those are all presumably going to be generally available at any time, but it's important to pay attention and try to maintain copies of those, or any orders that that a business owner thinks applies to their business. And I'll just mention as a side note, here in Louisiana, the governor issued an order and had to clarify at some point later that there were a number of businesses that closed that were not subject to closure under his order. They sort of assumed, I think, taking secondhand information about how the order was supposed to be applied. But while restaurants and gyms and theaters and a bunch of other things were typically closed, many other businesses were allowed to remain open, just with some limitations on their customers. And this applies frequently with restaurants. We handle a lot of restaurants, and many restaurants have the option here, at least, to remain open for takeout, which is not economically feasible for a number of restaurants, either because of the way they operate, the type of cuisine they serve, their staffing issues. So some can operate on a limited basis. Some are losing money even doing that. Some are just covering their costs. And then for some, it just doesn't make any sense at all, and they've closed up entirely. The interaction between those decisions and the actual orders that were issued is going to be important. And then, so that kind of plays into, some further here, some of the decisions that went into closing facilities. Any communications from customers or suppliers, definitely going to be important as far as why certain decisions were made and what options there were for either mitigating losses or possibly being able to continue to generate some revenue during this time. And then, all the employee policies and what's happening with sick leave. There are complicating factors coming in here with the PPP, the CARES Act, and funds that are being paid for that. There are businesses that are in a really tough spot trying to figure out how to handle some of those funds with employees who may be on, collecting unemployment at this point. And you can be pretty well assured that insurers, to the extent that there is a business interruption claim or a civil authority claim that's asserted, will seek to offset any losses with amounts that were, particularly any forgiven loan amounts under the PPP or any other government programs, that they would seek to deduct that from the total of lost income or lost profit during the covered period. So we can go on to the next slide. Again, there's additional financial information that's going to be necessary to maintain, and this is all kind of slam dunk information about what you really want to hang on to, all the P&Ls, costs, the payroll information, any additional costs for cleanup, steps that were taken to mitigate damages, whether it's and every business is different, but I mean, everything from securing a location that's physically closed to additional cleaning, additional staffing, sometimes temporary staffing that is required to either continue to operate or to shut down certain operations. The additional costs associated with remote operations for employees, because that's a situation that certainly comes up. And we've got another page of additional information having to do specifically with some accounting. I guess that's coming a little further, but there are, and I guess we've kind of discussed some of this, and this will all be in the list. These are just kind of notes to keep an eye on, that some business owners or insureds may not think are relevant, but it certainly could be valuable to the extent that this ends up in litigation. Is that, Mason, all of the information on documents? Okay. Brian, do you want to handle the likely outcome?
You can go ahead.
Okay. So this is really pretty much the summary of where we are. There's not likely to be some short-term answers on this. We have yet to see a general business interruption or civil authority policy where an insurer has agreed that there is coverage under COVID-19 without specific pandemic coverage. There are a few endgame kind of options that appear to be on the table. Clearly, there are going to be thousands, potentially tens of thousands of lawsuits that are filed seeking determination of coverage for business interruption or civil authority losses. Those are likely to be consolidated in some fashion and work their way through the legal system, resulting in some type of an answer at some point down the road. This is not going to be a short-term answer. It's not likely to be a short-term answer for any business. These are either going to be resolved by getting to the end of litigation, or there will be some type of mass resolution with claimants, with insureds, or there's the possibility, and I'm not kind of go through the outline, but it is entirely possible that the insurance companies, the way that the auto insurers have, where they've decided to, in a presumed show of good faith, to return a portion of premiums because nobody's really driving at this point, their experience ratio and their expenses are going down, so they're returning a certain amount of that goodwill. It is possible that the property insurers may seek to do something similar. They may make some cost-benefit analysis that paying claims for civil authority closures makes sense, and because those might be limited to only 30 or 60 days of losses, and some of that may be offset by some CARES Act proceeds for a lot of claimants. So the insurance industry could choose to do something voluntarily. We've also seen some action from states, not so much from the federal government, but I have a feeling that is likely to come at some point as well. 6 states at this point have introduced, the legislatures have introduced some type of legislation intended to force insurers to provide business interruption coverage. It's everywhere from New Jersey to Louisiana. None of those bills really seem to be making any progress at this point, but the idea was, honestly, it ends up being just kind of taking money out of one pocket and putting it in the other pocket, because the idea was, in all the bills that I've seen at this point, forcing insurers to pay a certain amount for business interruption coverage for businesses with fewer than 100 employees. Those insurance companies would be able to draw on a fund with the state, and that fund would be replenished with funds that were received by the state from assessments on future policies. So there could be a legislative answer. Whether that's a legitimate answer or not, we'll have to see. And then if there's no shortcuts to this, it's litigating through to the end. I think that there are any one of a number of very competent law firms out there who are proficient and taking these cases on a contingency basis, with the understanding that they're taking the risk on investing the time and expense in pursuing these cases, with knowledge that they may ultimately not be able to recover anything on behalf of their clients. But this is what we do. We fight for these things, and because we believe that that there's a legitimate, valid argument for coverage under the policies that we've taken a look at. Brian, do you have anything to add to that?
No, that sounds good. Mason, I think there's maybe a question that we can answer as we wrap it up.
We do have a couple of questions that have come in. So this is an interesting one. What warnings or guidance has the SBA given to recipients of either EIDL or PPP loans if their business interruption insurance claims are approved or paid? Would it look like double dipping to the SBA, in other words? So how do these two worlds meet in your minds?
That's an interesting question, and I'm not sure. I'm not aware of any guidance from SBA on that, and I think that it will be interesting to see the what ultimately happens in those situations. Those ultimately become, I think, kind of accounting and bank questions as opposed to litigation and insurance questions. I would honestly, I'd be out of my comfort zone starting to presume what may happen with forgiveness of PPP loans if an insurer ultimately paid on a claim. I don't feel confident in being able to respond to how the SBA or the bank would handle the funds that were used for paying the payroll and other expenses that were provided under those programs.
Yeah, I think what we do feel comfortable talking about is that if you got a PPP loan, for instance, and employee salaries and rent and utilities were part of your claim for business income loss or civil authority loss, the insured insurance company is going to argue that because that's forgivable, they don't have to pay it. So that is, and they'll say that's what they call an offset. So I suspect that will be argued, whether it's considered, I don't want to get too far into the legal weeds, but if that's considered a collateral source and they can't bring that into evidence or not is a different story for a different day. But it's certainly going to be argued by the insurance company.
And here's a big picture question that came in, also very interesting. If the insurers are even able to pay these claims if they lost the coverage argument, what happens then?
John, why don't you answer that one, since we talked about that the other day and you got the information.
Right. So this is part of the overall analysis of how this process may work. And I guess along with that, goes there are these legislative efforts to have insurers pay. Some of the numbers that we've seen are the bulk of the thousands of insurers offering property coverage with business interruption clauses have reserves of what's estimated about $800 billion. And businesses, even businesses with fewer than 100 employees in this country, are losing what's estimated at between $400 and $450 billion a month. So simple math is a couple of months of that would deplete the entire reserves of those insurers. That's not something that they are likely to be able to withstand, which is one of the reasons why if the pressure or the legislative environment is such to really put pressure on them, it would seem that there's an answer that would provide for them to be able to remain solvent and pay something without putting them out of business. But I also understand that there is discussion from most of the European reinsurers that there is sufficiently deep pockets in the reinsurance area to be able to cover significant business interruption losses.
So last question, as we wrap up, the possibility of Congress creating a fund to back up the claims paid by the insurance company, or the Congress themselves creating the fund out of presumably the Treasury.
And that's an interesting kind of an option. I mean, you know, there's certainly some thought that that the federal government will want at a certain point to continue to have money injected into the economy. It would seem that you know, there's the federal government can keep putting it in directly. I don't know that it makes a whole lot of sense to have the insurers pay and then have the federal government reimburse the insurers necessarily. And I don't know that that's what anybody's thinking about, but I could definitely see some federal legislative action that that would essentially seek to force a cash injection back into the economy that would come from the reserves of those insurers. Whether or not they would be able to be reimbursed for a portion of that on a from a further assessment level, and it would seem like that would be the most likely way to do it. The federal government wouldn't necessarily pay to refund or you know, reimburse the insurers, but the insurers would be able to recoup those costs ultimately through special assessments in future years. So, you know, that's the trade-off that I think that that is likely out there. To the extent that the insurers are required to pay, whether on a individual insured level or on a larger industry-wide level, there is I think a likelihood that the premiums may go up in the future.
Well, Brian, John, thank you for your excellence today in terms of your experience and all that you bring to this question. And we know we got a lot of questions answered from our attendees, delivered some good information to our attendees. Thank you for participating and being here today. And for our injury board members, thank you for making all of this possible. So just a reminder for all of our attendees, this is our speakers that were here, and you can see it's not repetitive. Looks like we've got it wrong here, but it's the lowercase letters, the B Katz and the J Creevy at hhklawfirm.com if you have direct questions for them, and we'll fix that deck. The deck we got a question in right at the end, will be emailed to you as a participant or an attendee of this. If you are seeing this and you know, maybe by way of shared media or need to get in touch, you can reach out to Judy Cheney at jcheney@injuryboard.org and ask for any of those in the entire series. We have one on remote work, we have one on the PPP loans, and then this one, of course, on business interruption claims. And so on behalf of Injury Board and our attorney members that are sponsoring this event today, thank you very much. And we look forward to seeing you at the next opportunity, and get ready to rebound. Take care.